I'm going to share a very common mistake that many people do and they end up being sued. I just had a meeting with a client who was trying to sell his property to a potential buyer. He signed an MOU with him and they set the transfer date after 2 weeks from that day. Unfortunately, the buyer backed out from the deal and never showed up to finalize the transfer. The seller was under impression that because of the buyer's obvious default and a clause in their agreement which says in case of buyer's default, this agreement will be terminated, he can simply consider this agreement as void and sell it to someone else. Wrong. That's not correct. When you sign an agreement with anyone, unless both of you agree to terminate it, you cannot exit that agreement for the reason of the other party's default. This termination has to be approved and acknowledged by the court only. Otherwise, the other party most probably will have the right to file a lawsuit against you. What I would suggest in this situation is to make sure that you communicate in writing with the defaulter and give them enough time to rectify their default. This is an important step before filing a lawsuit against them in the future.